Good morning, Your Honors, and thank you. Just very briefly on the, and I was the attorney for the plaintiff below. My name is Dan Cytryn, and so I'm just going to briefly speak about the closing. There was one objection sustained during the entire closing. There was nothing pervasive. It didn't shock the judicial conscience. It's an abuse of discretion standard. They objected and claimed that they were entitled to a remitter down below, and then they abandoned they basically abandoned their claim that it affected the damages. And in this case, I asked for 1.4 million. The jury returned like 600,000 intangibles on that amount. I was shocked personally when they came back with a 50-50 comparative. After finding that there were 8 prior incidents of people falling, and obviously, if you look at the video, you can see what happened to them on this video. So clearly, there's no reversible error, and this error was harmless beyond a reasonable doubt. With regard to the, I'm going to skip. I think the second point is meritless. With regard to the issue of wages, because basically if somebody has a permanent injury, it goes to the jury for the jury to make that decision. I want to point out to the court that counsel, I'm assuming inadvertently on this first issue, made an error and said that your case, Durst, decision was reversed for a new trial and implied that it was reversed for a new trial. It was reversed for a new trial because the trial judge didn't let in 100% of the medicals that were on a letter of protection. That's why it was reversed. And in that case, and in every other case in Florida dealing with medical bills, dealing with health insurance, dealing with every decision other than Medicare, the courts have always allowed the collateral source instruction, the collateral source rule to be the guide and to govern what's happening. And so Medicare is the only exception. The collateral source rule is common law. There has been nothing to say that there's no statute dealing with its evidence. The collateral source statute is a damage statute. There's been absolutely nothing to say that the collateral source evidentiary rule should be abolished. And Jorg said, unlike the common law damages aspect of the collateral source rule, the evidentiary, which is what we're dealing with, collateral source rule remains largely intact, with the exception of Stanley, which they overruled. And by the way, ThyssenKrupp conflicts with James and Winston Towers out of the 3rd DCA, but we have an easy way out of this ThyssenKrupp, whatever you decide, because we don't have to decide on ThyssenKrupp, because I've raised 2 issues that were not raised in ThyssenKrupp and were not raised in any one of these 4 or 5 Medicare decisions. Number one, that these benefits, the Medicare benefits, were earned by Mrs. Volin in her 27 years of employment, 16 years with Winn-Dixie, and even Stanley talked about they have to be earned in some way, and these were. And Durst was a case where they had no insurance, and this court reversed and said it doesn't matter that ultimately the plaintiff reduced and negotiated on his own with the medical provider to get a reduced amount that he had to pay back. The jury was still going to hear and pay 100% of the gross reasonable value of the medical bills that were introduced into evidence. In Jorg, they used the language, those who insure against the actions of tortfeasors should not enjoy the windfall at the expense of taxpayers who fund social legislation benefits. Medicare is a social legislation benefit. She helped fund it, and she is entitled to that. And they say that in Georgia, the Supreme Court said social legislation benefits are not an exception to the evidentiary collateral source rule. In other words, if plaintiff paid for and earned in some way, the collateral source rule allows the gross amount of medical bills into evidence. And Judge Artov, when you were a couple of years ago, actually it was 2016, Your Honor entered an order allowing boarding of full medicals, as did your other, I believe the majority of the other judges in your circuit, in a Medicare case, which I attached as supplemental authority.
Counsel, I'm not sure if that is supplemental authority, only because that was an interlocutory order where the plaintiff was moving for in limine, and it wasn't the defendant moving in limine to exclude it. So I'm not sure what was going on in that circumstance. I'm not sure I actually reached the issue, but I certainly I think that there was some discussion about the parties, perhaps in that case, the defendant in that case was comfortable with dealing with it as a set-off after the fact. So I'm not sure that's really supplemental authority, but I appreciate the shout out anyway. Thank you.
Yes, Your Honor. And by the way, what happened is some of these cases have conflated the evidentiary collateral source rule with the damages collateral source statute. And by the way, the collateral source statute, which was originally enacted in the Tort Reform Act of 1986, was amended in 1993 in two different places to specifically exclude Medicare from the equation and from the statute. So any of the rationale that goes into what other cases might have thought and said under 768.86 does not apply, because Medicare is not part of and is excluded specifically from the collateral source statute. And Judges Rothenberg and Shepard out of the third specifically said that a few years ago in the Humana case, and I believe one other judge, of course, said that also. And by the way, 2A, Title 18 is Medicare, where they're saying it's excluded. It says, but not Medicare. And so in Dial, they even were questioning what was going on there. And in a concurring opinion, Judge Yaucom admits that the prior decisions were wrong, basically, and says, but you know, I'm just sticking with it anyway. Thyris Krupp and its progeny has never held that in all five cases that the admission of the gross medicals is reversible error on damages. And what's incredible is when I started studying the statute, I said, what did we do? Because we should not have agreed to the post-trial reduction, that there is no post-trial reduction. Medicare is excluded from the statute. So the judges need to put up the full amount of the medicals, and that's what the plaintiff is entitled to, because the plaintiff, by paying in there, and for the number of years that the plaintiff did, is entitled to recover 100% of the Medicare bills, just as, well, not just as, but in this case, Medicare is actually an exception, and there is no set-off. And we can't just make up a set-off out of the sky, because that's what ThyssenKrupp did. ThyssenKrupp took and said, there's a set-off here. But where did it come from? It didn't come from the Florida Supreme Court. It didn't come from the legislature. So it was just made up for whatever reason. So in this case, not only is it not reversible error, but the defendant, the appellant, received the windfall of probably $80,000 or $90,000 that we should have left in there. So, and I point out also that there are problems with the practicalities of admitting the, of not allowing the admission of the gross medical bills. And number one, for example, the past medical bills are actually a measuring stick for the cost of future medical care. And that is historical. And I put in 8 other reasons, but I'll give you a perfect reason. If you just put in the amount of the Medicare lien, let's say the Medicare lien is 30 grand, and the defense is saying, well, they weren't entitled to get the chiropractor bills paid, and they weren't entitled to get the physical therapy bills paid. Well, how's that allocated out? We don't have those medical bills for the judge to say, well, I can make an intelligent decision if it's going to come to a post-trial reduction for collateral sources. The judge doesn't know how to, in any of these cases, whether it's under Medicare or if it's under regular health insurance. If they don't have the gross amount, the judge is never going to be able to figure out, well, how much did the jury give the bills for the chiropractor, or was it the physical therapy bills that they didn't give? So there's a lot of practicalities as to why this the full amount of the bills need to go into evidence. And I am going to go back to the lost wage issue. Do your honors have any questions on the either issue, on the closing or on the Medicare issue? So just briefly, in summing up, and I'm not going to use all my time, on the lost wage issue, Your Honor, Judge Artop has stated in one of your cases, which I don't have in my, well, you know what? It's not actually relevant to this opinion, so I'll move on but basically, if there is a permanent injury and there is evidence, and there's this woman, she was in a rehab first after she had the 3 screws put in her leg. She was in a rehab for 52 days, and then she went back to her job, and they said, well, you're going to have to stand for 4 to 5 hours at a time. So she can't even sleep through a night because she still has this pain, as the testimony showed at trial, and she still has the screws in her leg. So for the jury to understand that the plaintiff's doctor didn't know what the job consisted of, they can disregard, and the jury instruction says you can apply the expert testimony, you can just ignore it. And that was Judge Artop. That was, you wrote that in one of your decisions. So if the court has no further questions, I really appreciate the time, and I have nothing further.
Thank you, counsel. Ms. Klein?
Very briefly, on the first issue, what I think opposing counsel seems to be arguing is that this court should recede from Theisenfrupp and its subsequent cases, which of course means that the court would have to consider this case en banc or a rehearing en banc. But more to the point, what I think the argument seems to be is that now we have 2 cases from this court, Theisenfrupp, which says you have to move to exclude the gross amount of the medical bills before trial in order to be entitled to that. But then Matrascani says, well, if you don't move before trial, you're not entitled to a set-off. So between these 2 cases, what it appears is that this court, if this court doesn't actually reaffirm Theisenfrupp and say we meant what we said, then you have a tension between those 2 cases. You're urging litigants to make a pointless motion to exclude the gross amount of the medical bills, and then in Matroscani saying, well, we know it's pointless, but if you don't make it, then you're not entitled to a set off after. So I
Also,
think,
could you address the issue of the fact that it's a Medicare payment and whether or not it's quote unquote earned as opposed to not, and whether that has any, what the relevance is with our fourth DCA case law?
well, none of the cases that have dealt with this issue have addressed the specific argument that opposing counsel has made, and he's correct on that, that this is an issue of first impression. But opening that door to decide whether or not somebody actually earned it and to what extent did a plaintiff earn it really opens the door to all kinds of confusion, because Medicare is to some extent social benefit legislation, and it is not only available to persons who have earned it. For example, one who was never actually worked or worked very little is entitled to Medicare the same way as somebody who's worked all of their lives. So I don't think that
That's
distinction.
different, like for Social Security, we have earned years and all that. Has this been, is this an argument that's been preserved for below for our, or is this something for us that's appropriate for us to deal with right now?
I actually don't recall that it was raised at the trial court level. I think the court very, very quickly rejected really much argument, said, I rule this way in every one of my cases, and I'm not going to change my mind now. So as I rule in every one of my cases, I'm going to permit the gross amount of the medical bills into evidence. And that was...
I took a lot of your time, so why don't you just wrap up now?
We submit that the trial court erred in a number of ways. The first, in refusing to permit the reduction of the gross amount of the medical bills, in denying our motion for directed verdict and new trial on the loss of earnings and earning capacity, and on denying our motion for new trial on the grounds that there was an improper closing argument. And we would request that this court reverse the judgment with directions to the trial court to have a new trial on both liability and damages. Thank you.
Thank you, counsels. We will be in recess to the call of our last case.